In today's video, we'll be delving into the details of the Supreme Court case with the reference number as 180-2020, which is dated April 8, 2021. This case revolves around the cancellation of a contract and the issue of seeking reparation for lost income. Facts of the case. The involved parties in this case are the plaintiff and the defendant company, referred to as the service provider. They entered into two distinct types of agreements, one related to the construction of residential apartments, and the other concerning repair work. Real estate purchase agreements. The plaintiff and the service provider entered into a total of two real estate purchase agreements. The first agreement, dated September 22, 2012, pertained to the acquisition of two residential apartments in Batumi by the plaintiff. The second agreement, dated September 21, 2013, outlined the service provider's commitment to supplying the plaintiff with an additional residential apartment. Price and construction timeline. The plaintiff made payments totaling around $96,000 for these properties. According to the terms agreed upon, the construction was scheduled to be completed within 36 months from March 1, 2012, and the deadline was set no later than March 1, 2015. Repair agreement and associated expenses. Additional agreements were executed, one on March 23, 2015, and another April 23, 2015, through which the service provider assumed the obligation to perform reconstruction and repair tasks on the specified properties. The expense for repair services across all three apartments was around $68,000, of which the plaintiff paid around $43,000. Breach of the agreement. The service provider failed to meet the stipulated deadline for delivering the agreed-upon premises to the customer. Furthermore, the expert's assessment confirmed that the repairs carried out in the residential areas were subpar, and did not meet the standards outlined in the agreements. Court ruling. Asserted claims. In light of these findings, the customer communicated with the service provider company and made the following demands: compensation for the delay and for the substandard repair work. The service provider did not comply with the customer's requests. Consequently, on August 17, 2016, the customer initiated legal proceedings against the service provider, seeking a total of around $144,000. This amount included around $96,000 as the purchase fee, and $48,000 as the payment made for the repair and reconstruction works. Additionally, the plaintiff requested a charge of $1,000 per month from May 14, 2015, onwards, as compensation for lost income until the judgment was executed. The defendant company rejected this request. Lower court ruling. Batumi City Court rejected the claim, but the Court of Appeal in Kutaisi partially granted the customer's appeal. Specifically, the appellate court terminated the agreements and directed the company to remunerate the customer with the property's purchase price, and the sum paid for repair and reconstruction work. Moreover, a compensation of $23,000 was awarded to the customer as lost income. The court established that the service provider had exceeded the stipulated deadline for delivering the apartments, and despite receiving numerous notices, it failed to rectify the deficiencies in the repair work. Supreme Court ruling. The service provider company lodged an appeal which was partially upheld by the Supreme Court of Georgia. Specifically, the court declined to grant the request concerning the purchase price and lost income. Additionally, with regard to the compensation sought for the amount paid for repair and reconstruction work, which was $43,000 and $5,000 gel, the case was remanded back to the Court of Appeal for a review. Supreme Court on termination of the agreement. The Cassation Court elucidated that the pre-purchase agreement forged between the parties constitutes a mixed agreement, blending aspects of both a contract and a purchase agreement. The Supreme Court clarified that the contract termination represents a secondary right that materializes when the primary request is not fulfilled. The court opined that the customer's primary plea was the conveyance of property ownership. Consequently, the request to rescind the contract and reimburse the payment was deemed unsubstantiated. Supreme Court on lost income. The Supreme Court also dismissed the claim for lost income. Specifically, the court noted that, while a report had been presented suggesting a monthly rental estimation of $625 for the property, the uncertainty prevails over whether the plaintiff would genuinely have rented the property, the duration of such a rental, and the accompanying terms. Supreme Court on repair expenses. Regarding the expenses associated with repair and reconstruction work, the Supreme Court expounded that if someone doesn't fulfill their duties on time and it's seen as being late, the examination involves checking If this delay or not so great performance really fits the type of lateness that stops you from asking to fix the issue, also called an extra performance request. The Supreme Court remanded the case to the Court of Appeal for further examination. Rule of law. 1. Terminating the contract is a secondary right that comes into play only when the main obligation isn't met. 2. To claim compensation for the lost income due to being unable to rent out the residential space, the plaintiff needs to demonstrate not just the estimated rental price, but also their genuine intention to actually rent out the property. Connect with AI Law for expert legal services.